governing association for nationally, and part of SLRAC, which is the government affairs portion for agency. I've had the pleasure and displeasure of being on the Hill discussing this with FINCEN personally, and that is the Treasury Department. So FINCEN is the Financial Crimes Enforcement Network, and under that, it is their job, their role within Treasury is to help end or limit money laundering. A few years ago, FinCEN was extended to real estate. They had determined that a lot of money laundering was happening through real estate. Obviously, people can hide behind shell corporations and companies and those types of things. So they put in place what was called geographical targeting for real estate, and those were in big markets: Miami, Chicago, New York, New Orleans, LA, the places you would expect that those types of financial crimes might be happening at a larger scale. Well, they realized after a period that 60% of all money laundering from real estate was actually happening outside of those markets where it could be hidden. So the initial rule that put in that geographic targeting went into place, and throughout that period, they continued to amend that rule to encompass additional information. So 2016 was when the GTOs were put in place, and it covered specific zip codes within those major markets. Starting December 1st of this year, that goes into effect for all markets, all zip codes, and every transaction that is handled without financing. And that would be financing that would be done through a federally recognized mortgage lender. So what we want to start with here is to acknowledge that who this is going to affect. This is going to affect buyers and sellers on cash transactions where the buyer is an entity, if it's an LLC, a corp, a trust, or anything that would not be an individual person whose name would be placed of record for that transaction. And we all know that there's plenty of transactions that go out there that are through what we would call hard money, which would be lenders that are not nationally recognized mortgage lenders. Those are also subject to this FinCEN requirement. So this is 1 to 4 family homes, condos, townhomes, apartments. If it's a commercial transaction, it is not currently responsible for reporting. They do recognize that commercial transactions are potentially or very likely used for this type of money laundering, but they wanted to get this through to the residential, which is, obviously far more transactions per year than commercial transactions, and they're going to start there with the intention in the future to expand that into commercial transactions. As of right now, if you have a 1031 exchange, if you're familiar with that, great. If not, you need additional information. I'm sure Julie and I would be happy to meet with you to discuss what 1031 exchanges are, but they would be exempt from reporting at this time. Where this gets to be important for real estate personnel, at the time of listing your properties and you say, you're looking for transactions that have cash or mortgage or whatever, and you have someone come across and they are purchasing that transaction cash. To qualify that transaction, if you see that the buyer of that transaction is going to be an LLC, a trust, corporate, some form of entity, you need to know at that moment, we are going to be collecting your seller's data. The transferor's information is now subject to reporting through FinCEN. So what that would be is, I'm actually going to see if, Julie, can I show that particular?
What are you trying to show?
I'm going to show a different, I'd like to show a different item I'm not as familiar with.
You should be able to switch your screen.
Okay, let me just share. Here we go. All right. So can everybody see this document?
No, we're still seeing the slide,
Still
Mike.
see- Okay, give me a second. Sorry, guys. User error.
There you go.
We're just going to do screen one instead. That way we can put
That's
it.
good.
Now can everybody see that?
Yep,
All
we
right,
can see it.
perfect. So this is the American Land Title Association's proposed documentation because we do not have documents in place yet from FinCEN. Even though we're 2.5 months away from implementation, this is what we have in place right now from the American Land Title Association. This is likely what most people are going to use, or a form of white labeled version of this for collecting information. So this particular document here is actually for the buyer. I'm going to flip to the seller one. They're very similar. So you're going to have a why is it, did you receive this form? It's because your property is subject to FinCEN regulations and your information will be provided similar to 1099s when a seller is not exempt from reporting capital gains. We're kind of go down that same path of this is something that is federally regulated. It is not something that a title company down the road isn't going to be going to have to do. If they're doing it at this one, they have to do it at every single title company. So full legal names of all parties of ownership for the seller, the mailing address, their phone number, email information, stuff that we would normally have on file is not the big deal. It's when we get into the very specific items thereafter. What is the relationship to the buyer? Are they non-exempt? And what are the transactional exemption reasons? So a lot of this, we will be asking it to be filled out ahead of times and provided to us because we will not be able to close without this information in place. We don't want people coming to the closing table and not having information that we need in order to get this transaction closed. So we'll likely send this ahead of time, similar to when we send out, seller authorization for payoffs or those types of things. But we have date of birth, social security numbers of anybody who has an interest in that property, any type of unique information for that person, and then it will be signed. So the certification portion of it is being placed on our shoulders at the title company, and there's actually a chain that it would go through. So it eventually ends up landing on the title company escrow person's shoulders to certify this. So we need to make sure that we have accurate information because there are potential fines and criminal issues with this if it's not correct. So that's a little bit of our concerns as a title company is making sure we get that information. I will make sure Julie has these documents to send out to everybody so you can see it. This is based on information as we have it right now. It could expand. Estimated numbers of total pieces of information we need is about 110 to 120 pieces of information per transaction. And that's if you don't have multiple owners, say, on the buy side. So we go over to the buy side again, very similar information. The buyer is an entity, LLC. We will actually have to fill out all of the information as far as every single individual that has 25% ownership or more in that company. And there are some very complex businesses that are set up out there, which we would call, I'm sorry, I'm spacing on the word, but we'll just call it a chain of ownership. So you have an LLC that owns a property that, let me get to that screen. I actually have something similar to this. Go back. Missing a slide here. So I actually do not have that slide in this one because it's for realtors. But if you have an entity that has an LLC, single purpose LLC for purchasing of that property, and instead of having individuals who are the ownership structure for that LLC, you have another LLC that owns that LLC, which is then owned by another LLC. We have to go all the way back to the parent LLC that is the owner of those individual LLCs through. So there may be different individuals that are part of those chains as percentage ownerships, but if there's an LLC that's also involved, we then have to go back behind that and get the information. So it's going to be a very intrusive process. We, on the buyer side, when the cash comes in, we need to know account number, account name, beneficiaries of that account. And I believe that's the extent of it as of right now. There's been discussions of like when was the account opened and Several other things, obtaining operating agreements for each one of those LLCs in the chain. So there's going to be, on average, per file, about 3 to 6 additional work hours put into collecting this data, which means there are a lot of companies across the country who are talking about higher costs for this. There's probably going to be a fee for this. It is incredibly extensive and workload heavy. We're going to have to update some technologies. You may see some text message type requests that would put you into software that would give the person who needs to enter this information the ability to go through and enter that information in a wizard prompt, so they don't have to go and figure out all that paperwork. We haven't seen really good quality versions of that yet, but there are some of those out there that might make this process a little easier. I do believe that in-house we are working on some of those type of apps, applications, or integrations with our software that would allow us to send out push notifications for this. But again, we would need cell phone numbers, email addresses, and information to connect with your buyers and sellers to get that information. The most important thing about this is being proactive. So up front, if you're a buyer's agent and you know that your buyer is going to be purchasing a property cash and is buying it through an LLC, trust, or corp, just start asking for that information up front. If they already have told you before you even go out to sign on the dotted line of a purchase agreement that they're going to be doing it in that regard, just say, okay, we're going to need these items because the title company is going to require them in order to get this closed. We do have, like I said earlier, heightened penalties for noncompliance. There will be civil penalties. If it's negligence is, the willful, not wanting to do it entirely, and that would be criminal penalties would go along with that. But negligence would be just not going through the process to get it, not making the request and closing the transaction without making attempts. But I do believe that most companies are going to be in the opinion and have the process in place that says, if we don't have this, we cannot close, because we have to submit this information within 30 days, either the end of the month in which the transaction came to fruition, or within 30 days, which is ever longer. I think in most cases, it's likely going to be 30 days unless we're closing on the 1st or 2nd of the month. So it'll likely go into the next month, but we do have a time constraint on this. So we cannot close and then ask everybody to provide us that information thereafter, because that would put us in a really precarious situation. So I think the most intrusive part of this, beyond women, we typically are asking parties for their operating agreements and individuals who have rights to it so that we make sure we have the signers correct. But I think the part of this that makes it incredibly intrusive is the funding source portion of this. Asking your clients to provide their financial information to us as far as what account, who's the name on that account. And obviously, when we get a wire in, we can see some of that information, but it's not always clear as to who that is. So the beneficiaries of that account, the name on the account, and the institution, the account number, ABA number, all the stuff that we'd normally ask you for the wire right portion is what we're going to be asking for you for the internal going, so that we have that information to provide to FinCEN at closing. And I think that's probably going to be one of the hardest things to try to sell to your client, because we're asking for so much personal information on these transactions. It is a bit of a concern to us to have that information. We're required to hold on to that information for 5 years. Title companies are already a target for, hacking, piracy, and that type of information. So we're having to increase our securities just to make sure that additional now information that we hold is going to be safeguarded from those type of intrusions. So there's a lot going into this. We don't have final say from FinCEN. They haven't provided us with forms. They provided us with a link to the website for where this information will be entered, but there's nothing yet there for us to actually review and verify what it's going to look like and the final information that's going to be required. So that will continue to update over the next month and a half, I would say. We'll make sure to push that information out to everybody through our sales reps and through our email blasts, our social media, and that kind of stuff. You'll be seeing that from a lot of underwriters. They have people on staff that their job is to work with Alta, to go to the Hill, to work with FinCEN and the Treasury Department to help get us some relief on this type of stuff. To be clear, title companies, Metropolitan Title, we are all for limiting money laundering and the implications of that through terrorism and that kind of stuff. But it is an incredibly intrusive process. We hope you understand that this isn't something that we want to be doing for you and your clients, but it is a requirement similar to what we were doing with our reels and with the reporting to the IRS for 1099s. So bear with us as we get going through this. We are going to, again, be making updates as we know more information. But does anybody have any questions? And if you do have questions and I don't have the answers, I have some great resources at Alta I'd be willing to give a phone call to and get us some information on those types of things. But feel free to open this up to questions now, Julie, if you'd like.
Michael, I actually have a question. I was doing a little research on this on my own because my first thought would be, what's going to stop somebody from saying, okay, I'm going to buy this as an individual, and once we close, I'm going to go to the county and record a new deed, putting in the name of a business entity. And as I was looking into it, I did see that no matter how, anytime there's going to be a change of the deed, they're going to require that, no matter whether you're closing through a settlement agent or whether you're just doing a deed at the county. The county is also, correct me if I'm wrong, going to be requiring the same information. I don't know what that will look like in terms of.
If there's no entity such as a title company, real estate agent, attorney's office, that's where that kind of waterfall effect happens. It becomes the responsibility of whomever like that last person is to touch it before it gets recorded. Now, obviously, we're going to be doing that. If there is a transfer, now here's the thing: they put it in their individual name. It's likely going to be a straw person, and that they're going to transfer to the entity. But then again, that's that fraud portion of it, which we're not going to be able to really alleviate because we're not part of that transaction.
Right.
If they're buying it as an individual and they're providing cash, my guess is that they're going to use a straw person but that person's going to be on the hook when they make that transfer because they're going to start looking into who is the person that's selling it to them, what's their relationship, who is this entity that didn't report and may not have reported. So they can try to do that, but at the end of the day, at the time that they transfer it into the LLC, it's all going to become pretty clear when that information is provided. And they're probably going to try to do something that says that it was for zero consideration. And I don't believe that they've made it clear if zero is reportable or not. I have to look that up. I feel like at one point they did, and then they went to $1 or anything over 1 cent. But I would venture to guess at some point they'll make it so that if there's any transfer that goes from an individual to some form of LLC.
Okay, perfect.
But again, it's constantly changing.
Yeah.
And it'll be interesting to see what this actually does and what they're able to determine. I do believe that in the GTOs they had some type of enforcement, but what they did see was a decrease in transactions of this type in those markets. And I think that's why they said 60% ended up going outside of those markets, because obviously they knew it was now subject to, and so that wasn't no longer somewhere that they wanted to transact. Do we have any other questions?
If you guys have a question, go ahead and unmute yourself. And if you could, please just say your name and what area you're working in, just so we make sure we can follow up with you with our correct Metropolitan Title location if we need to provide you with additional materials. So we'll go ahead and open it up now.
Hey guys, this is Jen over in Lafayette. I just wanted to just touch base on what you guys were just discussing just a little bit, because I think that this is going to be the most common question that the real estate agents that are on this call and agents in the industry are going to receive. They're just going to want to buy it in their individual name to bypass that. So, for the majority of the people that are not laundering money, I think the best way to approach that would be, most of the things that the government's asking us to report, if they're filing federal tax returns, they're going to have most of that anyway. And if these people are considering just going online and doing their own deed, that is going to be a title disaster when they get ready to sell that property or, put a mortgage on there. So I think that we should try to avoid that avenue at all costs.
Right. And part of that too, that's a good point, Jen, is that the Business Transparency Act, the CTA, Corporate Transparency Act, already requires these individuals to report those when they create these LLCs anyway, if they get an EIN number. So again, the government already has this information. If you're doing it legally and you're not a money launderer,
Right.
It's no different. It is more intrusive just because we are going to be asking and being required to provide that information. But again, like Jen said, a lot of this has already been provided to the government if you went through the CTA. Good point, Jen.
Thanks,
Thank
Jen. Jeff Miles, I think you have a question.
Yep. Well, I just wanted to thank Mike for all this information, but and it sounds like unfortunately the brunt of this is falling on the title people, right? I'm just curious because I know how these things go with the government. Has this been out announced or planned for a really long time? Is there a chance it'll be delayed beyond December 1st?
So Alta is working to try to get it delayed because it's clearly not been fully fleshed out for purposes of December 1st. What FinCEN has said, I actually just watched one of our representative, gosh, I can't think of his first name, but Mr. Kennedy, who's with First American, who's on the board of Alta. I just watched him speak on Sunday or Monday of this week. And he said that the director of FinCEN has said that they're going to be lenient in the beginning because of where we are. But we've said to them that that's not acceptable. We need this to either be set in stone and we need to know exactly what's going to be expected of us, or it needs to be delayed. So we are working still at the federal level to try to get this delayed. But we've been trying to do that for about 2 years now. I've been to the Hill twice in the last 2 years, and both times we really got hit with well, this is going to happen whether you like it or not kind of situation. They really do want to do something about money laundering, and I think this is their clearest route to go about it. But I think that they need to really get a real standard operating procedure in place and be able to provide us with the actual forms and regulations that we're going to be expected to follow. So we'll see. Hopeful. I mean, it might be November, the last day of November, and we find out that they've put an injunction in place.
Sure. Thank you for all that. Yeah, I totally get the reason for this, and I support that.
Yeah, I think we all do. It's just the way that we're going about it and having to deal with regulation that is quite in depth is difficult.
Sure. Thank you.
I know
Thanks,
I
Jeff.
spoke quickly, guys, so I apologize. But if there's any questions, feel free to email us. I'm happy to answer. And again, if I don't know the answer, I'm going to tell you I don't know the answer, and I'm going to find someone who does, because this is something that is quite extensive and it's constantly changing. So.
Okay, anyone else before we end the call?
Can I say one more thing?
Sure, Jen.
So as a real estate agent, some things that we need to be extra cautious about. If the file does not start out as a cash transaction, it can easily flip to a cash. So what you may not think is reportable in the beginning can become reportable in the end. And so many times an individual is changed to an entity in the middle of a transaction. So if you are on the listing side, you also need to be staying on top of these transactions and communicating with the title company, making sure that the other side is cooperating so that there are no delays in closing.
Yep. So in our situation, I believe when that happens, our file or our system will be prompting our processors to be reaching out to the seller to notify them that we're going to have to collect that information if it is a cash deal. So hopefully your title company is going to stay on top of it, but obviously we're partners in getting this to the table. And so if you receive an addendum to the purchase agreement that makes that change before we're made aware of it, certainly get that to us as soon as possible. And then ask us to provide you with the proper paperwork to get that done and to fill out for your customer would be my recommendation. Good point, Jim.
All right. Anyone else? Okay, well, you guys have our contact information for each person in your particular area. If you have questions, please feel free to reach out. Like Michael said, this call has been recorded. I'm happy to send it out to you. If there's no more questions, I guess we can end the call.
Thank you, everybody. Appreciate your time.
Thanks, Michael.
Thank
Bye,
you.
guys.
Thanks,
Bye.
everyone.
Thank you, everyone.